Mr. Hunt, I'm going to have you go right to the podium there next to Mr. Travis. The record should reflect Mr. Hunt is present here in the courtroom today. This is People versus Thomas Hunt, file number 255028 and 5041. If I could have counsel take your appearances on, please.
Ryan Ziegler on behalf.
Kyle Travis on behalf of Mr. Hunt.
Thank you. This is the date and time set for sentencing in this matter. Mr. Hunt, have you had a chance to go through the pre-sentence report and talk to Mr. Travis?
Yeah, I was going through it when they brought me back here, but I got a chance to look at it. Yeah.
Okay. Do you need more time to do that or to talk to Mr. Travis about it?
No, I think I viewed enough of it. You know, I could get the gist of what's going on here.
Okay. Mr. Travis, are there any additions, deletions, or corrections?
I don't believe so from the defense perspective.
Any challenges to the scoring?
Not from the defense.
Oh, before we get to your challenges, Mr. Ziegler, do you have any additions, deletions, or corrections? And Mr. Travis, did you have an opportunity to review Mr. Ziegler's challenges?
I did, and we were just discussing the first one. I think Mr. Ziegler would draw the PRV5 objection. Other than that, I do largely think he's correct. The one thing I would note, Your Honor, and I've discussed it with Mr. Ziegler, I don't know that Mr. Hunt was advised of the risk of consecutive sentencing at his plea. Mr. Ziegler is indicating he largely is just noting that. He is not going to be asking the court to consecutively sentence Mr. Hunt. So I've discussed that with Mr. Hunt, and in light of the fact that Mr. Ziegler has indicated he's not going to be asking the court to do that, we don't really see any issue, but I just would point that out. I can't say absolutely, but I didn't recall that coming up at the plea. So I just would note that.
I would agree. I don't think it was brought up at the plea. It's not my intent to exercise discretionary consecutive sentencing under the facts of this case, but I do think it should be corrected because the PSI needs to be accurate in that regard. So we'll make that correction. Mr. Ziegler, is that correct? PRV5, your challenge is withdrawn on that?
That's correct, Your Honor. Mr. Travis last night pointed me to the correct provision of law. Those cannot be scored because they're predicates to the felony.
Okay. And then, Mr. Travis, I know you said that you thought Mr. Ziegler was largely correct. I don't know if that means you're not objecting to PRV7 and OB12.
I believe he is accurate. I think that the timing, since he pled to them on the same day, that there would be subsequent convictions. So they don't like it, but I think he's legally correct.
Okay.
And it's similarly in a review of the sentencing guidelines, I do believe it is 1 point because there was the dismissed operating while intoxicated theory.
Okay. And so those changes would only apply to the SIR in file number 5041. And that would result in a PRV7 score of 10 points, total PRV score of 25, and level B. OB12 would be scored at 1 point for a total OB of 11. It does not change the level. So the range would go from 0 to 17. Is that correct, Mr. Ziegler?
That's correct.
Is that your calculation as well?
It is what I reviewed and believe is correct.
Okay. Any other challenges, Mr. Ziegler?
No, Your Honor.
Anything on behalf of people for allocation today?
Your Honor, I certainly understand the recommendation for time served in this case. The defendant has almost 5 months credit, but I think that the particulars of the defendant's case or cases in this case merits more than 5 months. Of primary importance to me, Your Honor, the fact that he committed the second drunk driving offense while on bond to this court for the first. That, more than anything else about this case, speaks to the likelihood of danger to the community that Mr. Hunt poses when he is released. It's further noteworthy to me that all 4 of his drunk driving offenses, and I'm including one being dismissed by plea, have been in the last 8 years. This is not an old habit that he had when he was much younger and that now he's had a recent relapse. This has been an ongoing issue that the defendant has been struggling with apparently for at least the last 8 years. I would also note, as we discussed earlier, that the charges could be run consecutively, not asking the court to do that, but it does go to show that 5 months may not be sufficient to address the conduct at issue in this case, when that 0 to 11 and that 0 to 17 could be run back to back. His blood levels in both of these cases, these drunk drivings, were quite high, a 179 and a 183, both over the high BAC limit. It's also concerning that he got into a fight with officers, again, on bond to this court. All of those factors cut against a time served sentence, Your Honor. I think it's easy in this case to just look at the amount of jail credit the defendant has banked in this case and call that good enough. It's about 5 months. But I think in a vacuum, if we didn't have all that credit to look at, we just looked at what the defendant has done across both of these files and come to an independent conclusion about what amount of sentence that conduct warrants. I think it warrants something at the higher end of the guidelines, not something at the lower end of the guidelines. And so I would ask the court to issue an 8 or 9 month sentence on both of these files, concurrent with one another. Thank you.
All right, thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, as Mr. Ziegler points out, and as I was discussing with Mr. Hun when we were zooming in the jail about his PSI, Mr. Hun, I believe, made it to 70 years old without any criminal involvement. I found it rather shocking. It's not what I'm used to seeing. And we discussed that, and he's clearly had an issue with drinking in the last 8 years or so. Obviously, it's a problem. I would tell you, he comes before the court today having decided that he doesn't want to drink anymore. He's got family support. One of his sons is here. He's got another son local who's also been supportive during the course of the case. It's my understanding that they're they want to kind of re-embrace Mr. Hun. It's not necessarily that he had not had a good relationship with them, but I think both sons realize they need to become more involved in his life. And it's his intention to, I believe, actually live in a house one of the sons has inherited and help them clean that up and get it ready for sale. So there's activities planned there. Mr. Hun can express how remorseful he is about this, but he comes to the court having spent more time in jail by a massive measure than he ever has. So I understand the prosecutor's point that, hey, we've got one, we've got another, this is an escalation of things, but we've also had Mr. Hun having served basically 5 months in jail and basically a whole reset on his life as it was going into. At the time, he was living in an apartment with a girlfriend. He indicates to me that he believes that not drinking is something that he can do. A lot of that was just, not to blame it on other folks, but just the way he was living, the crowd he was with. And a lot of this, sadly, I think comes from him largely being retired. He worked a lot his whole life, even after the times indicated in the PSI. We didn't object because the PSI is not accurate. For a couple of years, he even continued to work a bit with one of his sons who worked in the oil field. His health just started to get to the point where he didn't feel that it was appropriate for him to drive a large work truck anymore. So he's now, for the past couple of years, he's been truly retired, and unfortunately fell into sitting around and drinking. And here he is with now a bad criminal record that he built in his 70s. So it's not as though he doesn't get that he can't drink. He doesn't get that he needs to change his life. It's become very clear to him, having spent, getting close to half a year incarcerated, which is something he's never done. So I understand Mr. Ziegler's point, but I think the effect has very much been felt by Mr. Hun. And I think maybe more importantly than just saying, oh, things are going to be better, having talked to both his sons, it's my impression that they very much are going to be more involved in their father's life because they see the need. They were quite shocked at just the state of his apartment, the state of his relationship, the state of his drinking, because he had been a vibrant father who didn't need to be basically kept up on before, and they realized that's not really the case anymore. Thank you, Your Honor.
Thank you. Mr. Han, anything you wanted to say today?
I apologize to those police officers that I apparently went off to the deep end or something and might have hurt them. I truly believe I have remorse for that. I don't intend to hurt anybody. It's not my intention to hurt anybody. And I guess I'm my own worst enemy when it comes to that. So I just like to ask the court to please forgive me and let me try this again. I can do this. I know I can.
All right, Mr. Hun, I did read through the pre-sentence report, so I'm familiar with the facts of the case and why you're before the court today. There's also a lot of information in there about you and your personal background and circumstances. So I take all of that into consideration along with what both of the lawyers have had to say and yourself here today. I think it is concerning that at this age, you know, you've developed this problem. And what concerns me is what the prosecutor said, which is, you know, the concern for public safety. When you're driving a vehicle and you're that intoxicated, you're putting yourself at risk, but you're putting other people at risk that are innocent, just out there going on about their lives. And you can kill somebody drunk driving at 70 just as easily as you can at 30 or 20.
I know. I'm sorry.
Yeah. And so my concern is making sure that you're going to get this under control so that you don't hurt anyone else, because I think you're lucky that you haven't.
I'm an alcohol abuser.
Yeah.
And I would like to say there's be no more drinking of alcohol on my part. I don't need it.
Well, and I don't think it's good for you because you're seeing what's happening on alcohol. And
Right.
whether you're an alcoholic or you're an abuser or whatever you want to call it, it's not a good substance for you because you do things when you're
Right.
doing that put yourself and other people in danger,
Absolutely.
including the police officers. So I think there needs to be a sentence here that addresses some punishment, but also addresses some supervision to make sure that you get on the right track and that you stay on the right track.
Yes, sir.
So I think the combination here of both of those is appropriate. So I do think probation, number one, is a good recommendation. I think that's going to provide the court with some assurance that you're not drinking and some supervision for you to make sure that that's being monitored. The court is going to impose some jail time with the guidelines here. I think I'm gonna impose a longer term of jail, but I'm gonna hold a lot of that in abeyance, which means that you don't have to serve it up front. But if you violate your probation or you use alcohol, then you do not pass go, you come right back to jail.
I understand, sir.
So I think hopefully that will provide an extra motivation for you to not drink.
Absolutely.
If you know that the result of that is going to be coming back here. So all of that being said, the court is going to sentence you to 12 months in the Kalkaska County Jail. The court's going to order that you serve 6 months of that up front. And the court will hold 6 months in abeyance to be served at the discretion of the court. You do have credit for 147 days served. The court is going to order that you be placed on probation for a term of 24 months. The court is going to adopt as the conditions of the probation all the terms and conditions that are listed in the report. The court is going to order that you pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, $68 state cost. The court is going to order that you pay a $30 per month supervision fee while you're on probation, and that's all as to file number 5028. As to file number 5041, 145 days in the Kalkaska County Jail with credit for 145 days served, a crime victims assessment of $130 and a $68 state cost. You do have the ability to seek an appeal of this sentence, and Mr. Travis, if you can have Mr. Hun acknowledge receipt of his appellate rights.
6-3.
Those sentences to be concurrent too, for the record. All right, thank you. We're on the record now. Is Mr. Warner present?
He is, Your Honor.
Jacob Warner.
Time to break this one down. The sentencing of People v. Thomas Hunn was both sobering and strangely uplifting. Rare blend that shows how the justice system can take a hard look at repeated mistakes while still offering a shot at redemption. Judge George Mertz presided with his usual firm, fair approach, making sure the legal boxes were checked, while also delivering a clear message. Enough is enough. But there's still a path forward. Mr. Hunn, 70 years old, stood before the court, facing sentencing on 2 cases stemming from multiple operating while intoxicated offenses, 4 in the past 8 years, with high BACs and even an altercation with police while out on bond. The prosecution, led by Mr. Siegler, made a strong case for more than just time served. He pointed out that 5 months in jail might seem sufficient on paper, but when you step back and look at the pattern, particularly the fact that Mr. Hunn picked up his second offense while on bond for the first, something sterner seemed warranted. His call, 8 or 9 months, concurrent sentences, within the upper range of the guidelines. Defense attorney Mr. Travis didn't try to brush aside Mr. Hunn's record but highlighted the unusual timeline, a clean slate until his 60s, followed by a late-life spiral into alcohol misuse. He painted a fuller picture of a man who'd worked hard, retired, and then drifted into bad habits in isolation. Mr. Hunn's sons, according to Mr. Travis, had been shaken by the state of their father's life and were stepping up to re-engage and support him. It was one of those moments that reminded you courtrooms aren't just about punishment, but about people taking stock. Mr. Hunn himself spoke with real remorse. No theatrics, just an acknowledgement that he'd hurt others, especially the police officers, and that he was, in his own words, his own worst enemy. You could tell it landed with the judge, who didn't gloss over the risk Mr. Hunn posed. Judge Mertz stressed the seriousness of repeated drunk driving, particularly at BAC levels of 0.179 and 0.183, and warned of the very real danger Mr. Hunn presented to the public. But instead of throwing the book at him, he crafted a sentence that aimed for accountability and change: 12 months in jail, with 6 months served up front and 6 held in abeyance, plus 2 years of probation. It was a middle ground sentence, stern but not crushing. The supervision component, with financial penalties and check-ins, adds a layer of structure that Mr. Hunn clearly needs. And Judge Mertz didn't mince words. If Hunn drinks again, he's back in jail, no questions asked. That kind of conditional sentence sends a strong message. The door to recovery is open, but it swings shut fast if the behavior repeats. In the end, it felt like the courtroom reached a consensus not on excuses, but on hope. Mr. Hunn's case wasn't treated like an anomaly or swept under the rug. It was a real-life example of how someone can lose their way late in life, but still be given a chance to get back on track with consequences, with oversight, but with dignity too. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.